Madam Speaker and members of the Assembly. This weekend, on May 17th, will mark the 60th anniversary of the Brown versus Board of Education decision, a landmark decision, probably the most significant decision in this country in relationship to education. Prior to this, in 1896, Plessy versus Ferguson became the law of the land, which dealt with separate but equal facilities. And it took almost 60 years to undo Plessy versus Ferguson. The interesting thing is that even though we talk about separate but equal under Plessy versus Ferguson, we sometimes overlook the Cummings law that followed it from Oklahoma. That was a decision that basically said that if finances are not available, then you don't have to produce equal facilities, which laid the groundwork for unequal facilities that were separate and became the law of the land. Many African Americans struggled with this for 60 years, creating laws and fighting court decisions. Thurgood Marshall talks about his battle with the University of Maryland that basically sent him to Howard University because they did not have a law school in Maryland to accommodate him. Charles Hamilton Houston became the hero in the civil rights struggle against segregation. He became the man who killed Jim Crow as he traveled throughout the South, pointing out the inequality of salaries and facilities and educational materials and opportunities for children throughout the South. So the Brown versus Board of Education decision in 1954 was a significant decision, not only striking down the separate but equal laws, but saying as a philosophy of this country that separate is inherently unequal, that you cannot have separate but equal facilities no matter how hard you try, that those facilities are unequal. And what he meant by that, of course, is that there is something psychological and something personal that happens when you separate individuals. When you separate them, you obviously imply that there's something wrong with the people that you've separated yourself from, that there's a reason that you benefit from not being around them because obviously they're characters that should not be included in your circle. And so this country struck down the laws of separate but equal. California obviously dealt with laws that were called de facto segregation, which were not by law, but by fact, that our housing patterns, our economic patterns, our working patterns created a separate educational system. And so long after Brown versus Board of Education, we struggled here in this state to integrate our schools. UCLA released a report yesterday indicating that California is the most segregated state in the nation in terms of education. Most of us should look at that report. It is striking because it really emphasizes the fact that also California has the highest level of poverty, the highest level of individuals living in poor housing conditions, and that poverty somehow or another drives our educational system and the opportunities for children. So as we celebrate Brown versus Board of Education, 60 years after Brown versus Board of Education, that really was a landmark decision about how we see ourselves as a nation. It says very clearly that we still struggle with the issue of equality and facilities and opportunities for all. I ask, as we look at ACR 140, I ask for your aye vote today, and I would like at the time to ask for co-authors of this matter. Thank you very much.
Mr. Fong, you're recognized.
Thank you, Madam Speaker and members. As chair of the Asian and Pacific Islander Legislative Caucus, I rise in support of ACR 140. It was only 60 years ago that the courts found that separate is not equal and that segregation was unconstitutional.